Yes, Mr. Clement, I managed to come without my notebook, but I am going to remember everything you say until my clerk comes back with it. So don't wait. I'll make rough notes where necessary.
In terms of the task your lordship set us over lunch, we have made a start, but it hasn't quite been possible to put down chapter and verse on it. Mr. Westgate and I have had a discussion. We wonder if it would assist if we produced a joint note for the court within a few days, so that we do actually.
That would be helpful, as long as the emphasis is on a few. I don't promise at the end of the day this will be the key to the whole case. It's just that since a distinction has emerged, well, there's a potential distinction between the position about setting aside and the position about allowing an appeal. I think it would be helpful just to have the basic building bricks. Thank you.
My Lord, we don't envisage never-ending rounds of written submissions. We'll endeavour to agree a document. If we can't, it will be one.
The substance, I'm sure, will be sufficiently reviewed in the oral argument. It's just to have a few references.
If I could add to your homework, I think a sight of the rules in Scotland might be helpful.
Yes, that is far easier to do, my Lord. We will do that. My Lord, yes. I have tried to condense down much of what I want to say, and I will finish my submissions with reference to my skeleton argument and attempt to speed matters up. But my fourth heading was, what is the nature of the abuse? And my Lord, in essence, we say it is a modified version of hunter abuse. What does that mean? That means the House of Lords decision in Hunter and Chief Constable of West Midlands Police. As always, Hunter itself is not in the bundle, but the relevant extracts from Hunter are in a different case. My Lord, it is, if I could ask your Lordship to turn to the Municipio di Mariana case, tab 19 of the authorities bundle. My Lord Justice Underhill might remember this one as well. I don't go to the facts at all. It just has a helpful summary and overview of the relevant general principles of the law on abuse of process. Page 348 of the bundle. My Lord, that has the extract from Hunter. It is misuse of the court's procedure in a way which, although not inconsistent with the literal application of its procedural rules, would nevertheless be either manifestly unfair to a party to litigation before it, we don't rely on that, but we rely on what I've termed Lim B, or would otherwise bring the administration of justice into disrepute among right-thinking people.
Thank you very much.
Well, that's what we say the Court of Appeal was envisaging. That's the kind of abuse the Court of Appeal had in mind in Mazhar. It's not a Henderson and Henderson abuse. It's not Johnson and Hallwood, which is all about you should have raised. It's a dispute between the same parties, and you should have raised the issue in the original claim. It's collateral attacks on earlier decisions may be abusive. That's paragraph 174 of the case that we have open. And we say, in addition to that, it's the constitutional principles that I've already highlighted. My Lord, what makes it abusive in this case? We say we have collateral attack on judicial orders. We say it is circumventing appeal routes that have been laid down by statute. We say it is circumventing the statutory filter of requiring permission to appeal. It is circumventing the statutory time limits. And it is the issues around the role of the Lord Chancellor and the constitutional principles that I have outlined. My Lords, we say if the High Court judge if the judge here is right, any claimant in any case where his liberty is at stake is entitled to challenge as a matter of right the legality of any judicial order up to a year after the event. We have set out the types of areas that are likely to be affected in paragraph 37 of our skeleton argument. That's the core bundle, paragraph 28. It sets out a number of areas where courts may make orders depriving individuals of liberty, where these issues are likely to arise. My Lord, it's not only...
Well, the existence of an ability to challenge as a right, as opposed to only with permission to appeal, was a factor which the court in Mazhar took into account as militating against the proposition that you could only appeal.
Well, my lord, that was if you had to put the claim for damages on the at the same time as the appeal. But what we're saying here is, if you appeal first, if you can claim damages separately without appealing first, you circumvent all of those particular requirements.
Right.
My lord, it's not just...
That might only be so if you hadn't appealed or the order hadn't been set aside. You're saying that the logic of allowing the judge's decision in the present case is that in any case where an order depriving you of your liberty has been made, you can simply ignore the order and bring your own separate proceedings under Section 7.
Yes.
Or Section 9, 1C. But maybe you couldn't do that unless the previous order had been appealed or set aside, which it has been here.
My lord, I think I would have to accept that in respect of the order that has been set aside. Of course, your lordship has my point that the other main order that's challenged by the claimant has not been set aside.
Yes.
But my lord, we do say the consequences for those who are doing the detaining pursuant to the order must also be considered, because if one finds in a claim for damages under 9(1)(c) brought a year after the judicial order that was made, if in that claim for damages the court finds that that order breached Article 5, then are we in a situation where those bodies doing the detaining do not have and never had any lawful authority to do that detaining in the first place, which is the primary element of my learned friend's claim. So one has to think as well, when one's talking about circumventing time limits and things of that nature, one has to think about the consequences for those who are all of those who are relying on those orders, not just those who are parties to it.
That often happens in a claim for false imprisonment. Police have arrested and they have 6 years to bring the claim.
But police have arrested pursuant to what, my lord?
Well, powers under the Police and Criminal Evidence Act, or and details from armed people in custody when they find.
But my lord, that's not a judicial. Here we're talking about a scenario where the lawful authority is the judicial order.
But your point is that the people who are dealing with the detaining wouldn't know where they stand. But
yes.
That happens in all actions for false imprisonment.
Well, my lord, that may well be the case, but what we're talking about here is a very particular cause of action arising out of a judicial order, which has, we say, if one is going to challenge a judicial order, we have an appellate mechanism, we have time limits, we have filters, etc. in place. And what this would do is allow to circumvent that with the corresponding impact on those who are doing the detaining. My lord, I have touched on this, but the claimant says that it can't be a collateral attack because the orders in question have been set aside. The three responses we had to that were that first, the claim against the Lord Chancellor is premised on the basis that the judicial orders are effective.
Sorry, say it again.
The first response is that...
You may have to speak up a little because there's a bit of...
Yes, scaffolding.
Yeah.
The claim against the Lord Chancellor is premised on the basis that the judicial orders are effective. And we see that, for your Lordship's note, I'm not going to ask you to turn it out, paragraph 43 of the particulars of claim, core bundle, page 89. Our second response is that the injunction, which contained the power of arrest, was set aside on the 30th of June, but it had practical effect before that date. We've seen a number of occasions when the claimant was arrested. And then the third point, as your Lordship has, is that no court has set aside the remand order made by His Honour Judge Hellman on the 19th of May 2020. So, my Lord, turning then to the grounds and the judgment below, we do say that the judge was wrong to reject the blanket rule, which is our primary submission, that it will always be an abuse if the judicial order could be and ought to have been appealed. And I've shown your lordship where that comes from, Mazhar. We say that is a result of statutory construction and the legislative history that I've shown your lordships in Mazhar. I'm not going to go back to it, I've already taken your lordships through it. We say it is also the logical consequence of the analysis of the Court of Appeal in Mazhar number 1. We say the correct analysis is that a claimant must challenge the judicial order by way of appeal or judicial review if that is available, and once that has been determined, either the appeal itself will determine whether there has been a breach of Article 5 or Article 6, or the appeal will at the very least determine the first stage of the Article 5 or 6 analysis, i.e. that the judicial order was unlawful, and then a claimant may bring a claim for damages under section 9(1)(c). So, my lords, what do we say are the errors in the judgment? The discussion, or the judge's discussion of the issue starts at Core Bundle page 70, paragraph 53. And there are 5 points that I want to make on ground 1. First, we say at paragraph 56, the judge was wrong to conclude that there is a danger of emasculating section 9(1)(3) if it is parasitic on a successful appeal or application for judicial review. We say our submission our interpretation does not emasculate section 9(1)(c). It still has an important role. It has a role after the courts have first determined whether the judicial act was lawful and or breached Article 5 or 6 of the Convention. Second, we say the judge erred in paragraph 57 in the second sentence when he says if it had been the case that the Court of Appeal had intended to limit the right to damages to the sequel to a successful appeal, it would have said so. Well, my lord, in our submission, that is exactly what the Court of Appeal did. That is the effect, the practical effect of the order that the Court of Appeal made in Mazhar. It stayed the claim for damages and required the claimant to pursue an appeal first. My lord, third, we say at paragraph 59, the judge finds this paragraph on paragraph 60 of the Court of Appeal in Mazhar. This is the discussion about when does one have to appeal and when can one set it aside, for example, for full and frank, where there hasn't been full and frank disclosure. And what the judge says there is that although there might not have been full detail as to the extent of the order, the courts of the same stand in the instant case pronounced on the setting aside of the orders in view of subsequent findings. My lord, your lordships have my 3 submissions on the relevance of that, and the key point that no one has ever set aside the second order that has been appealed. My lord, fourth is paragraph 61 of the judgment, and this is where the judge concludes that there is no rule of any kind, and that the court has to do justice in each case and adopt a broad merits-based approach. My lord, we say that gives no clarity at all to anyone who's seeking to interpret or apply the Human Rights Act, whether to claimants who want to know how they need to challenge judicial orders, or indeed to the Lord Chancellor as to how to respond to them. And my lord, what we would say there is, even if your lordship's against us on our primary submission, we do invite the court to give more guidance than was given in Mazhar about how these provisions should be interpreted and how they should be applied in practice. But my lord, what we say is it can't be, given the constitutional importance of Section 9 of the Human Rights Act, given that the approach to appeal at collateral challenge, it can't be a broad merits-based approach That is applying the test from the Henderson, Johnson and Wood abuse cases. This is a much more clear-cut, hard lines area.
You want a bright line rule?
I want a bright line rule, don't we all? But my lord, in this context, we really do need a rule or clarity as to how this statute is to be applied and interpreted in practice. If one leaves it to a broad merits-based approach, no one knows how it's supposed to work. There will need to be individual strikeout applications in every case, and there are already claims stayed awaiting the outcome of your lordship's appeal. My lord, finally, if I could take your lordships to the next paragraphs are all about assuming it is an individual broad-based approach. I'll come to that in my grounds 2 and 3. But paragraph 71 and 72, this is my fifth limb, is that the judge misunderstood and erred in his approach to the Lord Chancellor's constitutional role. And we say that the judge was wrong to reject the submissions that I've made to this court about the particular importance of the independence of the judiciary and the separation of powers. And my lords, in 71 and 72, the judge simply misunderstood the submission, or at least he rejected it in the context, as he says at paragraph 72, of a strikeout application. The existence of paragraph 72, the existence of a right to claim damages against the Lord Chancellor has as a possible consequence. The Lord Chancellor will, unless he or she wishes to capitulate, enter into the arena in order to defend the position. But as your lordships know, it is not the case of two commercial parties who can negotiate a settlement between themselves. The Lord Chancellor is in a very different position. The capitulate, in this context, means the Lord Chancellor is agreeing in collateral proceedings with a private litigant that a judicial order is wrong when that order has never been appealed. We say that is a fundamental constitutional principle. It does give.
I'm worried about the time. You've made these points already.
My lord, that was my fifth point on the judgment. In terms of on the blanket rule, in terms of the fallback position, that even if there is no blanket rule, there is still an abuse in this case. My lord, I can deal with that very briefly. We have set it out in our skeleton argument. Paragraphs 44 through to paragraph 49. My lord, ground 3 is essentially the same challenge, but with perversity rather than misdirection. My lord, in essence, what we say is that the judge took into account. It is a single right answer question, where the question of whether there is an abusive process is not a discretionary one. There is only one right answer to the question. The authority for that is in paragraph 44 of our skeleton argument. That is on to stores. I've got the paragraph numbers in the skeleton argument to turn down. And my lord, we say that paragraphs 69 and 70 of the judgment show that the judge is treating this as a discretionary question. We also say the judge has taken into account irrelevant matters, namely the case management issues that are relied upon in paragraphs. Sorry, I put the judgment down. In paragraph 62 onwards, and particularly paragraph 67, the case management issues favour Part 7 claim, support the submission that the claim is not abusive. We say that is not relevant to the question of whether there's an abuse, and in any event, we say that the case management issues are easily addressed. Both parties prepared a joint note after the last hearing about how they could be addressed. That is in the supplementary bundle at tab 4, page 15, and that sets out the route by which all of the judicial orders that the claimant wishes to challenge could be, permission to appeal could be granted in respect of all of them, and the appeals could be consolidated so that they are heard together before one judge in one hearing. So all the case management issues that have been identified can be addressed. My lord, the other points I wish to make are already in our skeleton argument. Given the time, I don't propose to add to those So, my Lord, unless there are any further questions, those are our submissions.
No. Thank you very much indeed. Yes, Mr. Westgate.
What I want to start with are some general observations about to the effect that we shouldn't lose sight of what abuse is all about at heart, and that the nature of the remedy, as it were, sought by the Lord Chancellor, or what they say is the abuse, or what they say is the difficulty that arises in these cases. I then want to come on and deal more specifically with my matter of principle. This is not because still as a blanket rule in the case. And in doing that, I'll pick up Mazhar. I'll then come on and deal with some of the Lord Chancellor's constitutional arguments before the remaining points on the grounds of appeal. But the first point I want to make is that one mustn't lose sight of the fact that this is an argument about abuse of process. And it's been hopefully clarified this afternoon that the species of abuse of process that's being under consideration is said to be a modified from the Hunter doctrine, where the thrust of the complaint made is that the process being adopted in this case brings the administration of justice into disrepute. There are various ways of describing that, but that's the thrust of it. And part of that is considering well-worn considerations that come into play in abuse of process arguments, such as waste of resources, multiplicity of proceedings, and so forth. And in the light of that, it's perhaps surprising that what the Lord Chancellor ends up proposing as a way of resolving the difficulties that they say are thrown up by Section 9, its interaction with Section 7 of the Human Rights Act, is what can best be described as a convoluted process that has various aspects of it which are frankly unreal and impractical. And if one considers some of the aspects of what they say is mandatory in a thing like this, the starting point is that they say, well, the appellant or the MTA must appeal. Leaving aside what the rules are, they must appeal. That's an appeal where, as far as MTA and the landlord's gateway are concerned, all matters have now been resolved, and there's no outstanding issue. It's a claim that, as between them, is purely academic. The Lord Chancellor says, well, it's not academic because MTA wants to pursue the appeal to claim damages. But that's of little interest or comfort to Gateway. And one of the authorities we have in the bundle is Hutchison and Popdog, that deals with academic appeals. And that makes clear that in deciding whether or not an appeal is academic, the court has regard to the position as between the parties. I'll just give you the reference.
Yes, well, that's a well-known authority, but they weren't really considering this point.
No, they weren't. But it's that's the way in which an academic appeal is normally considered.
Yeah.
And one of the other aspects of Hutchison, of course, is that if someone's to be dragged into an academic appeal, then they have to be protected in terms of costs.
But your point really is that the only possible purpose of an appeal would be to promote the damages claim. The landlord's not remotely interested in the damages claim because the damages claim won't be pursued against the landlord. So the only person interested in the damages claim is the Lord Chancellor.
That's right. And yet the Lord Chancellor is also saying that they won't participate in the appeal.
Yeah.
even though the rules expressly provide for notice to be given to the appropriate minister or the Chancellor only in a damages claim. So the rules appear to contemplate that the Lord Chancellor will be put on notice of the claim. There can only be one reason for that, to give them an opportunity to answer allegations in it. And so that perhaps tells against the idea that the Lord Chancellor shouldn't be an appropriate party in the appeal, but leaving that aside, what the Lord Chancellor is proposing is that there should be this free-floating appeal where they don't participate, the other side don't participate, and the solution proposed to that is that the court should appoint an advocate to the court, but the court doesn't do that routinely. It normally only does it where there's an important point of principle involved. And to say that the court should then have that additional expense and difficulty or activity foisted on it because of this procedure, it is not the way that the power to appoint an advocate is normally understood. Paragraph 3F deals with that. Then there are questions of costs as between the parties to the appeal. MTA will incur costs, but how is he able to get them back? Because Gateway would no doubt say, well, why should we pay the cost of that appeal? We've been brought in, but it has no interest to us, and is only an interest to the government. The Lord Chancellor is not involved in that proceeding because they.
Well, hang on. I think Mr. Clement suggests that Lord Chancellor would be formally made a party, you just not take part.
Well, not necessarily. I think the procedure that's recommended by the Lord Chancellor, if I've understood correctly, is that the appeal wouldn't concern damages at all. The appeal.
I don't think he said that. It might or might not.
Yes, but if it did, then there'd be no reason to be talking about the High Court at all, because the claim never arrives. Brought in the appeal court.
My understanding or misunderstanding of Ms. Clement's submissions was that she's submitted that you should appeal, and on the appeal you would then inevitably engage issues of Article 5.
That's right, but up to the point of damages. So in effect, what it said is that the appeal will deal with the liability questions.
Well, all right, yes, but that is, yes, I see. Well, you mean quantum, effectively.
Yes,
but that commonly happens. Quantum, this court quite likes remitting questions of quantum to the lower court. That's a red herring, isn't it? The important question is whether, on the appeal, the question of whether there had been a breach of Article 5 would be resolved.
Yes.
She was saying it ought to be. Though I think she conceded it might sometimes not be.
Well, and that we suggest is a telling concession, because certainly the Skeleton argument was made clear that the Article 5, Article 6 breach, yes or no question, the liability question, if you like, is something that was envisaged as being for the Court of Appeal and inappropriate to be addressed at the.
No, there's no doubt that was her primary position.
Yes.
The concession was simply cover a situation not unlike this, where on an appeal, the order was indeed quashed, but without trespassing on human rights questions. In this case, it could have been quashed on the basis that there was non-compliance with CPR 21.34 or whatever it is.
But if it's accepted that an appeal can suffice for these purposes, not to make the High Court claim abuse of process, when the appeal only deals with domestic law and doesn't deal with Articles 5 and 6, then that does raise the question about what the point of the appeal is. And I'll have more to say about that when I come on to why this is an abuse on ordinary principles. Because it's difficult to see, if that is the case, why the procedure that happened in this case isn't sufficient. Because
Well, I think the argument would be that even if convention issues hadn't been determined, you would at least avoid a situation where in the separate proceedings, the judge was having to decide whether a previous judge had made an unlawful order. That would already have been determined in the appeal, and therefore the judge in the Section 7 proceedings wouldn't have to decide it. More accurately, it wouldn't be a collateral challenge to it.
But it would then be a challenge that would address the question whether Articles 5 and 6 have been breached.
Yes.
And if one is concerned about questions of judicial independence and criticising the judiciary,
you say it's just as bad, even if the judge doesn't have to say that the appeal was unlawful, because that's already been decided. It's just as bad for him to say that another judge has acted in breach of convention rights. Is that your point?
Yes, and particularly as the foundation for that would be, we will call to mind tests such as flagrant denial of justice and gross irregularity. Errors of law happen from time to time, and in all courts, and everybody understands that. But if you're making a judgment about whether someone has frequently that's a different caliber of judgment. And it's difficult to see why one is objection and the other one isn't.
Yes, it's a double-edged argument from your point of view.
It's not, we say, when we come to consider the use of points in a little more detail, because it's clear from the Act and from Mazhar that the High Court has competence to decide that question. It's got competence to decide that question, and there has to be a clear and obvious reason to exclude it. But following on, though, once it's accepted that the Article 5 and 6 points may be separated from other points of law. What does happen, for example, if there's been an appeal on a point of law that isn't the Article 5 point, and then later on someone decides to raise that point, are they meant then to go back on appeal? Or is that something that enables them to go to the High Court? I mean, it might be said that in an example like that, then it wouldn't be reasonable to appeal, and therefore the claimant needn't do so. Once you start getting into reasoning like that, then the blanket rule goes. And if damages can be claimed on an appeal, why is a subsequent claim not barred by Henderson? And then there are further problems with an appeal as to what should the position be as to an out-of-time appeal. The point raised by Justice Lewison earlier on today, that he's in a position that an appeal can and should be brought if it's out of time. And if so, why? Particularly given what the Court of Appeal said in Mazhar about appeals out of time, about time when it's not being something that should be a bar. So the procedure which is being recommended is one which is complicated and which necessarily involves multiplicity proceedings for no obvious end. Because if a damages claim can be brought in court, it is difficult, why should it? But if but equally, what's clear is that Section 9 provides the option to bring a claim in the appeal court or in the High Court. And so there would be, it's difficult to see why there should be two sets of proceedings, but when one will do, whichever you take. So I start really with those points just to highlight the oddity of the appeal which is being suggested in a case like this, where it has no object other than to set up, as it were, a damages claim, but it does so
I mean, suppose you've got somebody who is committed for contempt for breaching an injunction.
Yes.
And that person's principal concern is to get out of prison as fast as possible. So he appeals against the contempt order, and he brings his appeal against the other parties to the litigation. And the court, let us suppose, allows the appeal for one reason or another. Now, he hasn't joined the Lord Chancellor at that stage because his concern was to get out of prison. So the question would then arise, well, is the Lord Chancellor bound by whatever the appeal court decided? And as you say, a claim for damages couldn't have been attached to that appeal without joining the Lord Chancellor, because you can't get damages against the other party for breach of anything. So it does raise difficult questions about how exactly you go about this appeal.
No, exactly. And it's, the point about the Lord Chancellor being, or potentially not being banned, was something that as Justice Freedman referred to. And it's a difficulty that arises on either the kind of case that the Lord suggests, or the procedure that Ms. Clements is suggesting on behalf of the Lord Chancellor, because she is suggesting whatever scope the appeal takes, it doesn't deal with damages, and so the Lord Chancellor wouldn't necessarily be a party to it. Wouldn't be a party to it unless it was a remedy. And then, of course, what's the Lord Chancellor to do? Let's say there's an appeal from a district judge to a county court judge that then reaches a decision on Article 5 and 6, which is wholly wrong. The Lord Chancellor hasn't appeared, so they haven't given guidance about it. The other party hasn't given any guidance about it. So the judge has been led into error. What's the Lord Chancellor meant to do then? Are they meant to say, well, I'm bound to stick with this obviously wrong decision, which seems to be the effect of the self-denying approach that the Lord Chancellor is taking? Or should they do something else? And all of those problems are simply avoided if one, instead of applying a blanket, applies what we would suggest is the conventional approach to abuse of process. Because the issues like re-litigation and issues like Henson abuse and issues like country abuse aren't exactly unknown to the courts. And there's a very well settled approach which has a fact-intensive, multifactorial judgment being made rather than dealing with matters like this on a blanket rule basis.
May I ask, just when you're leaving that,
yes.
I mean, on your analysis, is the Lord Chancellor bound by the fact that the circuit judge appears to have accepted Citron over the other expert? Because the Lord Chancellor might actually say, well, this chap did have capacity throughout. Or are you going to say, no, you're stuck now?
Well, it's. I think the logic of what I'm suggesting would have to be that I'm going to come on to say that the claim in this case between Gateway and MTA is a separate claim from anyone that MTA might bring against the Lord Chancellor, and so on ordinary principles they would be bound by it. There may be counter abuse arguments depending on how the arguments develop. But we haven't got there yet.
Hey, but that's why I asked you about
Yes.
the point of principle. Because it's all very well you saying, well, it's ridiculous to have this appeal. But on the other hand, the Lord Chancellor might also say it's ridiculous for me to have to be stuck with an expert who hasn't even been asked questions.
No, indeed. As I say, the answer to that is a nuanced approach to abuse rather than a blanket rule.
Thank you. Sorry to interrupt.
And can I therefore come on to make some general points then about the doctrine of abuse as it applies here? You were taken to the municipal authority about, and if I can ask you to return to because it's page 348 of the authorities manual, where it suggests the paragraph 171, citing Lord Diplock from Hunter. And it's the first part of that that I want to emphasise, that it's misuse of the court's procedure in a way which, although not inconsistent with the literal application of its procedural rules. So, and then it goes on to say that it would either be unfair or bring the administration of justice into disrepute. And so the starting point is that what's being done is regular from the point of view of the rules. And in this case, what we would suggest is that the High Court is competent to deal with all issues about an Article 5 damages claim or an Article 6 damages claim, including questions whether or not there has been a breach of Article 5 and Article 6, in the same way as the Court of Appeal is competent to deal with those issues. And that's what the Court of Appeal and Mazhar had in mind when it said there's no hierarchy between those various options. So what has to be said is that procedure, which is on its face valid, is abusive in one of those ways. And in addressing that, the broad principles are ones that are expanded on in the ECHR decision, paragraphs 173 through to 177. And I emphasise.
Sorry, 173. Where? What are we?
Well, it's saying it's a municipal case. It's page 348 of authorities, and it refers to Johnson and Henderson, talking about a broad merits-based judgment, which takes account of the public and private interests of both. It takes account of the facts of the case, and then it refers to collateral attacks may be abusive, and at a little bit further down, sorry, Lord, then a little bit further down at paragraph 177, leave aside 76, it makes the point that a finding of abuse doesn't automatically lead to a striking out claim. The court retains discretion as to the appropriate response. And then that's 178. Litigants shouldn't be deprived of their claims without scrupulous examination of all the circumstances, unless the abuse has been sufficiently clearly established. And then there's a little bit later on, it talks about clear and obvious cases being needed to justify striking out. So that's the background approach, and although it's articulated there in connection with a Henderson type of use, similar principles apply in Hunter type cases or collateral challenge cases, and we refer to paragraph 37 of Gazprom, page 279, for that point, where page 279 of the authorities bundle, and various principles are set out there which are extracted from the cases earlier, saying there will be an abusive process only if manifestly unfair or bring the administration of justice into disrepute. Two limbs, including the public interest of the state in not having issues repeatedly litigated.
So where are you reading from?
Page 37, page 279, paragraph 37.1. And then two, there's no general rule preventing a party inviting a court to arrive at a decision consistent with that arrived at in an earlier case. It's sufficient for such an abuse to be found to exist merely because earlier proceedings have been conducted. Must be some special reason. Then some of this is specific to a particular kind of context. But at 5, we see, in order to determine, the court must engage in a close merits-based analysis of the facts, taking into account the relevant private and public interests, citing Michael Wilson. And then it sets out a number of considerations, including 6A, whether there was a reasonable opportunity to deal with the allegations in the earlier proceedings, and then B, whether the party advancing the allegation was also the party advancing the allegation in the earlier proceedings, C, whether the party wishing to advance the allegation had earlier adopted a contrary position, and so on. But the point I extract from that is in Hunter-type cases, just as in Henderson-type cases, the approach is a multifactorial. Note also in the list of factors that in page 281, letter E, one of the factors is what's the most appropriate tribunal, and F is what's the purpose of obtaining relief, whether it's a genuine relief sought or some collateral purpose. And then G, whether the relevant party was at some disadvantage or subject to restriction. So all of those may be factors that come into play. If one then comes to the context of this case, what we suggest that there's a distinction to be drawn between the two claims which are potentially in issue in this case. First is the gateway claim against MTA. And when one talks about appealing that decision or setting it aside, the issue is whether the claim as between those two parties remains, or the orders as between those two parties remain valid. I'm using fairly broad language at the moment to avoid arguments about that issue and so on. But what is concerned in that proceeding, be it an appeal or some other process, is whether one can set aside the proceedings as between those two parties. That's a completely separate question from whether or not one of the MTA is then entitled to pursue the statutory tort established under the Human Rights Act as against the Lord Chancellor, seeking damages in respect of earlier judicial acts. And the reason it's important to distinguish between those two is that it's important not to get distracted about the process of setting aside the first one, because it doesn't necessarily bear on the second decision, on the second kind of claim. The second kind of claim may be an abusive process if sufficient consideration isn't given to the first decision. But what it doesn't mean is that one has to necessarily set aside that first decision in its entirety or in a particular way in order to defeat an abusive process argument in respect to the second. And where that leads is that the other processes, other than setting aside on appeal, may have sufficient potency, as it were, to undermine the basis of the first claim, so as not to make the second claim abuse. And indeed, Ms. Jones appeared to accept that at the end of her submissions, because she appeared to accept that some other order setting aside the orders in the gateway claim would suffice other than appeal. And if that's the case, then again that undermines the blanket proposition that one has to have an appeal. Because what one then has to do is widen it and say, well, there has to be an appeal or some other equivalent process. There has to be an appeal or some other kind of setting aside. And rather than endlessly try and qualify or refine the blanket rule, our approach would be to say, well, these are all matters that are capable of being taken into account in the broad exercise highlighted in Municipal and in Gaspar.
May I ask you about an example? Suppose a High Court judge makes an order, no one's gone to a motorway, then he commits someone for breach of that order. There's no appeal or setting aside, and then 9 months later, the person who's been committed to prison brings a claim under Section 91C before the High Court for damages. Will that necessarily involve a collateral attack on the first judgment?
It would be very likely, because the premise of the claim would be, I would never have been ordered not to go on the motorway. And one is then simply saying that you can't succeed in the claim without showing that an unappealed judgment is wrong.
Thank you.
And there's a difference between that kind of case, obviously, and a case where the earlier decision has been successfully appealed, because then the decision is gone. But there's no reason why the same kind of result shouldn't follow from a different kind of process that undermines the order. And of course that is what one has in this case, where if we go to the perhaps I ought to deal here with the point that was raised earlier in the submission this morning about what the relevant orders are here, and what the basis is for them being set aside. Can I park that now and then come back to it? It would be really part of the response to the some of the specific submissions about whether or not there is an abuse here, but I'll come back to it.
Can I just ask you another question?
Yes.
Mr. Westgate. Suppose you've got an injunction in ordinary civil proceedings, and somebody is committed for breach of it, and he wishes to say the injunction shouldn't have been granted, and succeeds. There would normally be a cross-undertaking in damages from the person who obtained the injunction, which he could then enforce. How, if at all, does the existence of a cross-undertaking in damages affect the interrelationship between the possibility of an appeal on the one hand and suing the Lord Chancellor on the other? Is that a mitigation of damages point which the Lord Chancellor could take? He would say, well, you should have appealed this order. Perhaps it's run out, so there's no need to appeal it because it's time limited. You should have appealed it. You would then have been able to enforce your undertaking or cross-undertaking in damages. Does that have any bearing or not?
It shouldn't have a bearing on whether you're entitled to bring the claim. It may potentially have a bearing on whether it's an abuse in the sense that if there's some other way of achieving what you are setting out to achieve. It's also, I think, fair to say that it's rare to have undertakings in damages in this, or certainly in the kind of case we're dealing with.
Oh, of course. That's why I say
yes.
Ordinary civil proceedings, because I mean, if you get an antisocial behaviour injunction,
yes,
there won't be a cross-undertaking.
No. But in a case like that, then it will be one of the factors that can be taken into account, and it's it will potentially go to what the object of the claim is. It's difficult perhaps to see why it should ever make it abusive on its own, because there would ordinarily be an interest in pursuing a claim that your detention was wrongful, and if that's a genuine concern, then it's not something that would be trumped by the fact that you're able to get some financial advantage elsewhere. And indeed, that, I suppose, is an aspect of what arose in Mazhar, where once the damages claim was dealt with, the legal side of the damages claim was the Chancellor. Mr. Mazhar's only But Lord, the general point I make about use are the ones that I've highlighted, that there's a settled approach that it should be dealt with on a broad merits-based judgment. That's exactly what the judge did here. And his approach is something which we suggested on impeachment. And the blanket rule, which is set up, proposed to be set up by the Lord Chancellor, is one which flies in the face of that merits-based judgment, and we can already see is vulnerable to having to be over-refined to take account of various exceptions, which would normally be part of the overall merits-based judgment. In addition to that, it sets up a process which is that's what unhappy principles that I go again. But what I would like to come on to now is to deal with made one point about the decision in Mazhar before coming on to deal with some of the points raised by the Lord Chancellor and to respond to some of the further points being made about the blanket rule. Because it goes to the point I make about the competence of the High Court to deal with all issues. Because it's important, we suggest, to recognise how Mazhar got to the proposition they did about 9(1)(c). And if one goes to I'll start at page 294. Authorities bundle.
240.
294.
294.
And it's the paragraph, the paragraphs beginning under the correct interpretation of the 1998 Act. And you were taken to this by Ms. Clement, but paragraph 40 to 41 run through the Act. They refer to section 7.1, providing that a person who claims a public authority has acted or proposes to act may bring in proceedings in the appropriate court or tribunal. And then it goes on to say that such rules have been enacted. And it says CPR Rule 7.11.1 provides that a claim under section 7.1a in respect of a judicial act may be brought only in the High Court. Any other claim under that provision may be brought in any court. You don't have 7.1.1, but that's in effect all it says. Section 8 of the Act, then paragraph 42, deals with damages. And then at paragraph 43, we see the observation that if matters are stopped there, the scheme of the Act is clear. An act, including a judicial act, made unlawful by section 6.1, would lead to a right to bring a claim under section 7.1 to obtain appropriate remedies. In essence, that's how Mr. Tomlinson invites us to interpret the 1998 Act. Now, of course, it's crucial to recognise that what's being argued for here isn't a claim limited to damages. What's being argued for here is that the court, because of the section 7.1a, has power to, or the High Court has power to make a general declaration, not limited to Article 5, but any article, because the Mazhar claim was about 5, 6, and 8, when only 5 at the time, empowered the court to grant any damages. The court then goes on to say that if matters don't stop there, the Act must be read as a whole. And then one has the review of the history, which you were taken to this morning. But before one gets to what the court then concludes after that, it's clear that from the recital of matters up to 43, that by including the High Court as the court that is the appropriate court for the purpose of section 7, the Act, unless something else happens to cut it down, confers full powers on the High Court in respect of those acts. The court then goes on to address the history. I'm not going to take you back to that. But then at paragraph 54, one gets the passage that you were referred to, that when the final version of section 9 in the light of legislative history, it's clear that the way in which a judicial act is usually the subject of proceedings is by way of an appeal. But then what the court is there addressing is usually to be the subject. It is any kind of claim, not an Article 5 claim. Then it goes on to say that the only circumstance in which a claim is permitted on Section 9(1)(c) is where it's necessary to enable the claim to draw damages, limits the circumstance in which the High Court can act in relation to a judicial act having those consequences. But that's all it does. It doesn't take away anything else from the High Court's powers. So in other words, the High Court clearly has full power to adjudicate on all issues arising under that damages claim. In passing here, we suggest that it's not possible to read the word necessary there as only applying post appeal. Lord Justice Freedman J this morning that one shouldn't use the statute. And of course, what it's doing, or what the passage is distinguishing, is between general claims that can be brought in by appeal and damages claims that can be brought in by an appeal or in the High Court.
And do we now have to read into paragraph 54 damages claims for breach of Article 5 and now 6?
And 6 to the extent that they're dealt with
by way of amendment.
Yes.
Yeah.
So what you say this passage is doing, the force of this passage is distinguishing between, you said, general claims.
Yes, so a claim for of the kind that Mr. Mazhar wanted to bring in that claim, which was either for a declaration, which is an exempt for damages, or a claim in respect of an article that wasn't Article 5, both of which he was trying to do.
Hang on one second. So that's the general claim. It's the distinction between that and a claim.
It's distinguished between that and claims in respect of which were claims for damages for unlawful detention, where a special rule is made, and those where it's necessary to bring damages to those, then they can be brought.
In the context of Section 9, we're only dealing with claims for damages for unlawful detention anyway, aren't we?
No, because if you go to Section 9, I can take you to the section itself. That's page
291.
Yes, I was going to the current version in bundle, which is page 10. And Section 9 deals with proceedings under Section 7(1)(a). And proceedings under Section 7(1)(a) are that's a person who claims that a public authority has acted in a way which is made unlawful by Section 6, which is acting incompatible.
Sorry, where are you reading from?
That's page 7.
Sorry, I thought you were looking at page 10.
Yes, I'm sorry, I was, but I was taking you back to page 7, which is 7(1)(a), which is what's referred to.
Yeah.
Page 10. So the proceedings under 7(1)(a), and 7(1)(a) tells us that those proceedings are proceedings against an authority on the basis that it has acted or proposes to act in a way which is incompatible.
Yes.
And so if one comes back to Section 9 in page 10, 9(1)(a) and B allow a claim to be brought in respect of any breach of the Human Rights Act. So would.
Well, and C, surely.
Well, I'm sorry, C would, but the forum, the way that the court reads the inclusion of the High Court in in section as the appropriate court for the purposes of 7.1a is to say that that is a form prescribed by the rules. But when you look at it in context, it's only doing it in respect of Article 5 claims.
I'm not saying you're wrong, but where do I get that from?
It's Mazhar. It's the passage we've just been looking at in Mazhar. So if I can.
I'm bound to say I'm completely lost, Mr. Westgate. I'm sure it's my fault.
No,
You're trying to explain para 54 in Mazhar.
Yes.
Let me just read it again myself. So what's your explanation of the second sentence? Tell me one more time.
Well, is that it's drawing the distinction between an Article 5 damages claim.
Yes. Because 9.3, that's the only kind that can be brought.
Yes, which is the only kind of claim permissible under 9.1c.
No, under 9.3.
No,
9.3. I'm sure I'm getting this wrong. You just have to forgive me. 9.3 says that you can only get damages in a good faith case for effectively for a breach of Article 5.
Yes.
But on the face of it, you can get such damages under 9.1a, 9.1b, or 9.1c.
No, you can.
So what are you saying?
So what 54, the second sentence 54 is saying, is that the only kind of claim that can be brought under 9.1c as opposed to 9.1a and b is the Article 5 claim, now Article 6 as well.
Yes, that is what it's saying, yes.
Yes. But the background to that are propositions about the general power of the High Court by designating it as a body which is the appropriate court under Section 7. And I make the point to highlight that the High Court has got full and equal power in relation to that 9.1c point, as has the Court of Appeal or Court on Judicial Review.
Yeah, ma'am. Sorry, I've diverted you.
Well, it may be a point that perhaps has moved on a little bit, because the point of making that distinction, making the point, is to highlight that the High Court is as much concerned with dealing with questions of liability in relation to Articles 5 and 6 as is the Court of Appeal. So the suggested distinction is in some ways the Act prioritises the appeal to judicial review as being the one by which liability for Articles 5 and 6 should be litigated, rather than the High Court. It is unfounded.
But we already know that. That's been decided. That they say that in terms later on in that.
Well, they certainly accept that. The terms seeks to interpret that as meaning that the process has to be sequential. So there has to be an appeal. And certainly, as the argument was initially put, and as I understand it's still put in the third, the argument is that although there is no hierarchy, the Court of Appeal ought first to deal with, although there's no hierarchy, there's no hierarchy in relation to damages alone, but as regards the question whether there has been a breach of Article 5 or 6 in the first place, that's something that ought to be dealt with on appeal. But that is not the statutory scheme. Lord, can I then come on, having made that point, I'll come back to some of the other paragraphs of Mazhar shortly, but so far as the blanket rule is concerned, and this really is the main point raised by the appeal, what we say is that the blanket rule doesn't follow a matter of principle. I think most of the points I want to make of that. But also it doesn't arise, or Mazhar doesn't mandate it. And indeed, Mazhar is the overwhelming sense of the decision of Mazhar is that 9(1)C is available as a freestanding matter. And that's certainly the way it was interpreted in the later Mazhar 2 case. But dealing with the issue first of all as a matter of principle, I'm perhaps recapping some of what he said, that even assuming that an appeal is the sole route to challenge a decision for an error of law, that doesn't in itself exclude a freestanding in aid of the statutory tort created by 9(3), because the point about abuse of process in one sense is this type of abuse of process is predicated on a decision not having been appealed. The question is, notwithstanding the fact that decision stands, is this an affront to justice such as an abuse of process? So it can't be an answer in itself that the decision hasn't been appealed. And in the face of a different claim, as one has here, as the Lord Chancellor, the fact that there's an unappealed decision covering the same ground may be kind of relevant to whether there's an abuse, but it doesn't entail a blanket rule. The Lord Chancellor relies on paragraphs 60 and 70 of Mazhar, which you was shown this morning. I won't ask you to read through them all again. They deal with an argument to the effect that, well, the preamble was an argument to the effect that there might be some decisions that couldn't be appealed at all. That was rejected. And so the court then went on to say that normally where there's an error of law, the decision has to be appealed rather than challenged in some other way. All of that may be so, but it doesn't address the question of abuse, because the question of setting aside addressed in sections 60 and 61 are to do with the position as between the legal parties, rather than whether another claim brought against somebody else is abusive. Because a claim which is brought against the Lord Chancellor is separate from the earlier claim, and so the question that matters for the purpose of an abuse argument isn't the technical one of has it been set aside by appeal or something else. It's what weight should be given to the unappealed decision.
I must say, I find paragraph 60 very hard to understand. It's dealing with the case of an application granted without notice. And if the judge makes a mistake about his jurisdiction, because it's not, the limits of the jurisdiction has not been brought to his attention on the without notice application, but the respondent brings that to his notice on the return day, why shouldn't he set it aside?
No, indeed. It may be that these paragraphs don't reflect on what's now fairly common practice.
Well, you said what's now, what was ever. It's not as if there's been some change in practice since 2020.
It's possible to say that in the without notice example, the reason why the claim is set aside isn't for error of law. It's set aside because there's an entitlement to revisit a without notice application once it's come on notice.
But one of the reasons for revisiting might be an error.
No, indeed, but the distinction might then be said, well, you had to distinguish between the occasion for revisiting it and the grounds on which you do so. It's pretty much a distinction without a difference. But even if it's right, it doesn't really bear on the abuse point, because the abuse point is asking a different question, which is notwithstanding the fact this case hasn't been appealed, is it an abuse and so inconsistent with that decision as to be in the front of justice? And it's obvious, with respect when answering that question, that there may be other steps that have been taken that are as good as an appeal for those purposes. And we suggest that's exactly what you have here. Just to take the point briefly about what the basis of the claim is, you've seen the grounds. The claim is in respect of each of the individual decisions, whether to make the order or to not to cancel it or revoke it, and the decision is on the Judge Hellman, which we accepted that is a separate decision to remand, but it's one which is predicated on the power of arrest being a valid power of arrest, and is also itself something we say which is captured by CPR Part 21.3, so it's invalid once that issue is resolved. And so the claim is based on each of those orders, both as regards their individual and their cumulative effect. And the reason why the individual claims, each of the orders is part of the claim, is that may have a bearing on whether or not there's been a flagrant denial of justice or a gross irregularity.
Well, hang on. I thought it was because each detention is a separate breach of your client's liberty.
No, well, that's also the case. But part of the claim is to look at the process overall.
Well, I dare say, but I mean, I thought for a moment what you were saying was you were really only looking at the individual cases as part of some.
Oh no.
I mean, there are. I can't count them up. Effectively, there are 3 unlawful detentions, aren't there? 2 where he's detained overnight in a police station, or maybe 3.
I think it's 3. Yes.
3, and then a 4th when he is remanded.
Yes.
Each of those is a separate cause of action.
That's right.
Each of them depends, as I think we've established, on the original order of Judge Manners, because that's where the power of arrest comes from.
That's right, and we would certainly say that
And in the case of Judge Hellman, although that order was made for had a conceptually different basis. It was remanding for a in the context of a committal application. You say that's not a material difference because it all goes back to the original injunction.
Yes, well, we say it's not a material difference too. One is it's predicated on the original judgment, so it's substance. It's not that different from the exercise of the power of arrest. In the remand power under Section 9 only apply to something called power of arrest, and all the powers to remand only apply if there's a power of arrest. There's no valid power of arrest, no valid remand. But also each of those, we say, is a step that is rendered ineffective by Section 21 of our CPR 21.3. And we have done some research in relation to the point about what step covers. It's something that was done some time ago, so it's up to date. But there are some authorities that give support to the idea that court orders are steps.
Have we got those authorities?
We've got. I wonder if, given the time, it might be something that we can include.
Well, I'm sorry, but if it's rather an important point in your whole case, then why aren't they in the bundle in the first place?
Well, it's not something that it's our substantive case, but it's.
Well, it doesn't matter. Sorry, I was just being catchy.
Really in response to the point made by Ms. Clement on the bench this morning.
Well, let's have what you've got.
Can I pass up Alexander Hotels and Blake Coulter? Is this the number? Yes, there's 7 copies here.
Thank you.
Yes, if I can ask you to just go to paragraph 18, which explains that a trial took place, and judgment was then entered against all defendants. And then it says, pausing there, it appeals in the transcript, that before entering judgment, the judge didn't take course either requiring him to prove or striking out the defence. And then as to Alex, who's a minor, says the judge evidently proceeding with his chair by the parties. From us, the resolution 2025, this leads to preliminary comment concerning the order against Alex. As a matter of fact and law, he had an litigation friend. This was evidently no fault of the claimant company. However, the consequence of the absence of a litigation friend is the order against Alex, whilst the reminder is of no effect unless it is ruled otherwise.
Yes.
That's probably the clearest thing. Obviously, it's pre-Mazhar. It's not referred to in Mazhar. But of course, it deals with what we suggest is a completely different point. Because it's one thing to say that an order has to be complied with, even if it's apparently invalid. It's another thing to rely on a separate set of principles, which is that people who lack capacity can't be expected to comply with orders and can't be expected to play any part in the process.
So just while you say that there were several cases to this effect. I mean, this, as far as it goes, is explicit. So it's not fully argued. But are any of the others as strong or stronger?
This is probably the best.
That's the best case. Well, it's up to you with what you want to cite, but we wouldn't want to be in ignorance of any other case that was dealt with it substantively.
Would you go on a minute? And there's one where there was a decision where the litigant did have capacity, but the judge did it in the alternative.
Well, all right, but can we, if we haven't got it here, could it just be sent to our clerk?
Yes, of course. I mean, it may be something that we should perhaps, given the way it's arisen, and the reference to the jury this morning, it might be something to add on to the short note.
Well, I'm not sure, but the moment. All I'm interested in is seeing such case law as there is about the effect of 21.34, yes, given the submission that it doesn't apply to orders.
No, but as was also observed this morning, it's common for second to be incorporated in orders, and those to be set aside under 21.3, and it's unsustainable.
Yeah, it may well be, but just while we're pausing on these technical points, you said the power of remand only arises where there's a power of arrest. Were you referring to a specific provision of the
yes.
2014 Act?
Yes, I am.
Can you just give me the reference?
So it's section 9, which is the power to remand, and it's page 31 of the bundle. And it provides that where a power of arrest is attached, then a constable may arrest and bring the person before the court. And then 9.5 says the judge before whom the person is brought may remand the person if the matter.
Thank you.
But at all events, in addition to the express wording, we do have the order of District Judge Swan of the 30th of June.
Yes.
Which is page 246 of the supplemental. And the recital for that is upon the court noting that the finding that the second defendant lacks litigation capacity was explicitly based on the court decision, to the effect that the second defendant had been incapacitated since birth. And then the order is the second defendant's discharged from his arrest, and secondly, importantly, the order of the 17th of February and the power of arrest attached thereto. So those are the two things that are causative of the...
So sorry, which one are you on?
Paragraph 2. The order of the 17th of February 2020 and the power of arrest attached thereto are of no effect and are set aside, pursuant to CPR 21.34, insofar as they relate to the second defendant. So it's not right really to describe this as a prospective setting aside. It describes the order as being of no effect
because that's what the rule says.
No, indeed. And true it is that it uses the present tense, but that has to be read against the recital to the effect that the defendant's incapacitated since birth.
Well, yes. But that's why I just wanted to understand what's meant by the concept of setting aside. Normally, in ordinary legal parlance, I think, if you talk about setting aside an order, it means it ceases to be of effect as from that point.
Yes.
And you don't change that simply by reciting that the person has been incapacitated since birth. If formally, I mean, this may not be fatal to your case, but if Judge Citron had meant to, not Judge Citron, I'm sorry, Judge Swan, meant to quash the order ab initio, assuming he had power to do that, that's what he would have had to have said. But maybe he didn't have any power to do so because
Well,
he's not an appellate capacity.
But he said, didn't he, Mr. Westgate, in paragraph 2, that the order of the 17th of February is of no effect.
Yes.
And that reflects Rule 21(3).
No, exactly. So
It never had effect.
Well, that's the effect of 21.3.
Yeah.
And he's using the language of that.
So it's not setting aside in quite the way my Lord Vice President is thinking, I think. What he's saying is this never did have effect.
No, exactly.
Because 21(3) stopped it having effect, unless the court otherwise ordered. And we've seen from Mr. Justice Sewell's case that that's something which the court may not do.
Yes. And certainly the court doesn't do it here. So he could have validated these orders, but chose not to. But yes, it's not a. It's a statement of the effect of the rule. It's a point that we would make, and indeed do make, that the rule has effect whether the court has recognised that there's a lack of capacity or not.
So it's effectively declaratory.
Yes.
Of what has been the position ever since the order was made,
Yes.
purportedly made.
For what it's worth, or maybe nothing further turns on it, there's a statutory power under Section 8 of the 2014 Act to apply to vary or discharge, which can be exercised once as of right and further times with the court permission. It doesn't say what it means about, it doesn't say what discharge means. That's adding to the
Well, discharge again, it may well be that in this particular context, we've got to give the words a broad meaning. But the concept of discharge, to me, means the same as what I was suggesting set aside normally means. As from now.
Yes.
Certainly discharge tends to mean that. It was valid until now, but now it's been discharged.
No,
so set aside may be more ambiguous.
It's something which the Act doesn't say what the date is for which you discharge, and there's no reason why you shouldn't be able to discharge retrospectively. You don't have to.
But anyway, it would be a shame if this case turned on technical points about what is in the abstract meant by terms like discharge or set aside.
Indeed.
Your point is that the effect of this order is that a judge has effectively said that the order of the 11th of February, which is the foundation for all the detentions which subsequently took place, was of no effect.
Yes.
And that is enough to dispose of any point about collateral challenge in the proceedings that you have now brought.
Exactly. And the technical points we say don't arise because you have to recognise that it's a different question that's being addressed. The question isn't what effect does this order have. The question is it an abuse? And in answering the question, is it an abuse, you can take a much broader view of what's happened to an order as a matter of substance, rather than asking technically, has it been set aside, when was it set aside, and so on. And that, in effect, was the approach that the judge took in this case, because he was fully aware of the difficulties that one has when one puts together all these recitals, and said, well, there may be questions arising, about the date of the incapacity and the effects of it and so on. But, he said, on what the court has, there's not enough to say that this is a clear and obvious case, that this is a case where there's such an inconsistency with the earlier decision that it's abusive.
I think if you look at page 240 in the bundle, which is the district judge's judgment, at line 20, he says it follows the order made originally in February against the second defendant is of no effect.
Yes.
CPR 2134.
And he goes on to elucidate that by saying that
they must be set aside. So
yes.
he is, the reasons for his order make it clear that what he's doing is giving effect to the CPR.
Exactly. But when one, particularly given the submissions that were made this afternoon, where it appeared to be accepted that one could have an alternative process to an appeal having an equivalent effect, it's impossible to say that's not the case here. And so, whatever the position about blanket rules or not blanket rules, this is the case where there has been an equivalent to an appeal. But the main thrust of the response to the appeal is that it remains that it's not necessary to go by appeal first of all. For the reasons I said, that's not compatible with principle. I'll just deal with why we say it's also not compatible.
It would be odd on the facts of this case as well, I thought, to appeal against an order which never had effect.
But that may be where the Mazhar line of reasoning comes in. Just because an order is void doesn't mean you can't appeal against it. It's not competent to appeal against it. And certainly if an appeal had been lodged, it would be impossible to say what are you doing here. The order is invalid. So
Yeah, the appeal would be the vehicle for
yes.
finding that it had no effect.
Exactly. But it's not the only vehicle. Because it depends on the fact find. So where we got to is I've made submissions about why we say the blanket rule is wrong in principle. I've made submissions about why, in a particular fact of this case, there has been an order which is the equivalent of appeal. I want to just deal with Mazhar about what it said about the appeal question and whether that has to precede the claim under 91C principle, which is appeal abroad. First of all, it's notable that in Mazhar, number one, there was no argument in that case that there had to be sequential appeals and then a damages claim. The argument in Mazhar was that any claim for damages had to be brought by way of an appeal. That was rejected, and in a sense, the current argument is an attempt to resurrect the argument that was rejected in Mazhar. But doing so comes up against the same obstacles that face the primary argument in Mazhar. First of those is the point in paragraph 63 that the court said that such proceedings under 91C brought before an appeal or without an appeal being brought are or may be an abuse. We'll come to what may means there, but nowhere in the decision is there any suggestion that a claim can't be brought without an appeal, and indeed paragraph 63 suggests that it can be so brought, it's just that it may be vulnerable to being an abuse. And specifically what the court held, one goes to paragraphs 62 onwards, it's paragraph 62 is the rejection of a statutory hierarchy. And of course, if one has a regime under which an appeal has to be brought first before 91C can come into play at all, then of course there is a hierarchy, because the 91C claim can only come after one of the others. And then paragraph 63 is the passage I've shown you about how it may be an abusive process. Then at paragraph 64, disagree with Mr. Krasinski's submissions that we don't think it's right to say that a claim for damages under section 91C in respect to the High Court must be brought to appeal, and then it can and usually would be brought by way of the originating process, pursuant to section 91C of CPR 711. But the reference there to 711, we suggest, is instructive because it refers back to the High Court being the designated court. And again, there's no suggestion there that can only follow after an appeal. Surely, if the court intended to say that, then that's exactly what it would have said. But the last sentence, that something usually would be brought by way of an originating process, is flatly contradictory to that. One gets the same point at paragraph 97, which is on page 305. And there the court is addressing a point made, I think, by Lord Diplock, and saying that that was relied on before Lord Justice Ryder, and then it says the final bit of that paragraph, that doesn't, however, lead to the conclusion there can never be an action by way of originating act process in the High Court under section 91C. In our view, there can be, as is consistent with the wording of both the Primary Act and Rule 711 of the CPR. Indeed, as that rule makes clear, in respect to judicial acts, the High Court is the only correct forum. So again, the court is referring back to the primacy of the High Court being the only correct forum. Then if we come back to paragraph 64, one then goes on to paragraphs 65 and 66, which were accepted this afternoon or this morning, I think, to be elucidating 64 and giving reasons for that conclusion. And when one looks at the reasoning in paragraph 65, it describes the operation of the section in practice. And again, there's no suggestion there that it has to follow an appeal. And then at 66, which is also by way of explanation to 64, there is an acceptance about the surprising and undesirable consequences that might follow. And although some of these are referred to by the Lord Chancellor in support of their conclusion, or in support of their submission, it's clear here that the court considers them to be reasons not to limit section 91C. So it says that to require a person to bring a claim to damage in respect of judicial act would mean very short time limit, would have to be applied with 21 days, compared to the normal time limit. It would mean the claim couldn't be brought as of right, but only with permission. And it would lead to procedures such as disclosure of documents, and then to make findings of fact which are better suited to the court of first instance than to an appellate. Now, focusing on those separately, or the first two ones separately, the time limit and permission, the suggestion was made today that that doesn't mean that that doesn't put a block on the right to claim damages as of right, because you can still claim damages as of right. But that doesn't work because the appeal is still a gateway to being able to do it, and you still can't bring your damages claim if there is an absolute rule if you have an appeal under those provisions. And so they do remain as much an obstacle to the sequential argument as they do to the original argument. And then the third point is particularly apt here because it particularly pointed to issues being determined on liability as to in the High Court, because it refers to disclosure of documents and findings of fact, which are the kind of things that one would expect to find on the flagrant denial of justice side of the line, rather than on the quantification of damages side of the line. So So all those pointers suggest that the Court of Appeal had clearly in mind that the High Court was an appropriate court to begin proceedings without an appeal first having been brought. One then has to come back to paragraph 63.
Really just to elucidate my thinking, if one looks at the 5 categories of types of case in which a wrong decision may also be a breach of Article 5, which are helpfully set out in Mazhar 2 at 328, quoting from LL, most of them are not actually going to require significant findings of fact, are they? The court acting without jurisdiction normally be a purely legal matter. I suppose there might be some findings of fact about dates of things which are relevant to jurisdiction. Sorry, am I going too fast for you?
No.
That's one. There were gross and obvious irregularity in the court's procedure. Well, again, those things are normally documentary. You may occasionally have to have findings of fact about what happened at a hearing or something like that, or whether a document was sent. 3, an order, no proper foundation in law because of the failure to observe a statutory condition precedent, not much fact there. 4, arbitrary, which is glossed as complying with the principle of certainty. And then 5, things that went wrong during the proceedings. So that on liability, often you're going to have findings of fact.
Well, it's
you might, in another matter, you might on quantum, depending how long the detention was, and there might be quite a lot of evidence about how the effect of the detention, but otherwise not.
Well, perhaps it's pointing to where there's going to be evidence on potentially either side, although one can easily see that jurisdiction looks like arbitration, but it
Yes.
may not be.
Okay, I'm sorry, I was really, again, just thinking aloud in case you had any
Can I just
observations on that.
confirm what
Yes.
your case is on the claim against the Lord Chancellor? If we look at that, what do you say you are? Without jurisdiction because he lacked capacity? Or is it because there was a failure of a condition precedent, namely he lacked capacity? Or gross and irregular, which is what you pleaded?
We pleaded gross and irregular, and I think with this list, it's without jurisdiction, possibly, although it may well be that the court under 21.3 has got power to amend, so it may be able to allow some to proceed, so it may well be the jurisdiction point wouldn't be one. Certainly gross and obvious irregularity, and then no proper foundation in law, because the condition precedent is you have to have capacity.
And in this case, if the Lord Chancellor wanted to, assuming it's not an abuse, and the Lord Chancellor wanted to defend the proceedings, then there might be the factual inquiry about whether he did,
Yes.
in fact, have capacity at material times of the order.
No, exactly.
Yeah.
Yes, that's a good example of why my list was perhaps too narrow. Capacity would be a fully fledged factual question.
Yes, no, whether it would certainly come within arbitrary as well, whether or not MTA had capacity and was able to compile any. I'm going to try and finish this line of points, then I've got some points to make about the Lord Chancellor's quandary argument. So far as paragraph 63 is concerned, which is the one that says that it may be an abuse process if an appeal could and should have been brought. The Lord Chancellor seems to say, well, that may in fact mean must, but it's impossible to read paragraph 63 in that way, and every reason why it shouldn't be read in that way, given that may is in conformity with the general approach to abuse. And secondly, it's instructive that the court uses the language of could and should, which is as important as the use of the language may in that paragraph. And again, it brings the case into line. with the ordinary approach. Nothing we suggest can be gathered from the fact that permission to appeal was granted in Mazhar, because that was a claim for a declaration. And it's not the case in Mazhar that damages claim was found to be abusive, as the Lord Chancellor suggests in their skeleton argument.
Yeah, sorry, when you say could and should, that's not a direct quote, but there you're referring to could, can be, and ought to be.
Yes.
Yeah, yeah, fine.
And that really leads on. We've also dealt with this in our skeleton argument. It also does lead on to the question whether this is the case that ought to have been appealed. And again, the abuse authorities are very clear that one, particularly the Henderson cases, where the question is an issue that could and should have been brought in earlier proceedings, that one should not and cannot infer should from could. Because the question whether or not somebody should have done something is something that is to be judged according to what would be reasonable for them to do.
Yep.
And indeed, the standard is perhaps rather less than that. In the Dexter and Leland body case, an Albion, which is paragraph 19, page 129, when else you send it up. The court asked whether a decision was sensibly open to the person, and if it was, then they should be held to have done something that they decided to do by that standard. And in this case, we've already explained that the points about the appeal being academic and appeal having no interest, difficulty in recovering costs, and so on, always being good reasons why the appeal couldn't have been brought or should have been. And of course, throughout the period of proceedings, until the orders were made on the 30th of June, the MTA lacked capacity, so it couldn't appeal. And so it's impossible to say that he could or should have appealed, given his lack of capacity, because a litigation friend was only appointed on the 23rd of June. And of course, by that time, was then only a week away from the order of District Judge Swan. The obvious thing to do is apply to them. And of course, by the time MTA is in a position to do something about it, the issue is gone. So it's simply not one of those cases where there could and should have been an appeal, even if that's the correct approach. Can I go on now to deal with the, as far as the grounds of appeal are concerned, one point which is raised, which I perhaps deal with separately from what we say in the skeleton, is what's being effectively floodgate. The argument is put that if the Lord Chancellor is not right, the judge is right, then anybody can bring a claim as of right. The fact is, we would accept that in very many cases where nothing has been done to undermine or take away the basis for the original decision, then proceedings would be reconsidered. Because in those cases, what you are doing is bringing a claim that simply flatly contradicts a decision you've chosen not to appeal. That's far from this case. And the judge expressly found that this was a case where there was a risk of inconsistency with the decisions of the courts below, which qualifying as abuse. But coming on to the constitutional role point and the constitutional quandary, it's not a matter. Again, it's perhaps significant. This is something of a late comer to this litigation. It wasn't something that featured early in Mazhar. And before.
I thought we were showing that it did. I thought we were showing the point was taken by before Lord Justice Ryder.
Initially before Lord Justice Ryder.
Yes.
The submissions took issue with merits. It seems only later as part of the argument that this point developed. But anyway, be that as it may.
Well, it's a bit of a debating point anyway, isn't it?
There are a number of objections to it. We've got 6. Firstly, the Lord Chancellor doesn't explain why it is that the constitutional rule with regard to independence of the judiciary means they can't make submissions as to whether or not a decision is party says that upholding the independence of the judiciary isn't inconsistent with expressing disagreement with the decision or making submissions about the correctness of the decision before an independent court, because the essence of that process is that you're respecting the system under which decisions are made by independent judges and are then adjudicated on by independent judges. And such a process, even though often critical of the decision, respects the right and duty of the judge to make a decision independently. And that's exactly what is happening in this case. It's what's happening on this appeal. It's what ministers and the Attorney General do all the time.
Well, it may depend where your disagreement is expressed. I mean, if you loudly disagree in the Daily Mail, that may be one thing, but if you disagree in another court,
yes,
that may be different.
No, absolutely. If you disagree in court, then you are bound by various rules of procedure in court as to the way in which you express that disagreement.
Yes, but I mean, that's a point, but it's not real. The fundamental point is the forum.
Yes.
You can't be said to be disrespecting the rule of law, to be challenging one decision of one court of another in a court.
No, exactly. And so the point simply doesn't arise. And if it did arise, then it would also apply in proceedings to which the Lord Chancellor or any other minister is a party. And the Lord Chancellor hasn't explained why it is that the rule only runs when expressing disagreement with a decision in proceedings to which they are not a party, particularly when the rules expressly provide them to be joined to that claim. And it would be bizarre if the rules meant that the Lord Chancellor should be joined only then to decide that they shouldn't participate. And so the rules, we suggest, are drafted on the premise that the Lord Chancellor may well appear, and there's nothing improper about that. And it's notable that in framing rules under section 7 of the Rights Act, I think it's section 710, the person framing them has to have regard to section 9. So it can't be said that the point hasn't been taken into account.
So that's the first.
So that's the first point. Second point is, if this was the hallowed rule, it's said to be, then one would expect it to be referred to in cases or academic texts or conventions, none of which have been produced. Thirdly, this point perhaps I've already made, if the Lord Chancellor is right, then the same duty applies to any other minister, and they will be subject to the same inhibition, and much litigation will come to a standstill, which may or may not be a good argument. But fourthly, if the Lord Chancellor is concerned about this, then section 9.5 allows them to nominate somebody to act in their place. And it's also the case that they can do much to mitigate the difficulty through independent advice. Fifthly, it's hard to understand why the same wouldn't apply to the damages part of the claim, which the Lord Chancellor accepts should be brought in the High Court with them as part. The judge was right to hold that the issues here are likely to be at least as contentious. It's one big canvas earth, but it's one thing to say there's been an error of law, it's another thing to say it's been a flagrant denial of justice.
Do you mean the damages part of the claim, or do you mean the part of the claim relation specifically to... Well, I suppose it's the same thing, specifically to Article 5, because you can only bring an Article 5 claim if it's for damages.
That's right, but the reason I say the damages part of the claim is it's responding to the Lord Chancellor's primary position, which is that the liability has to go to the High Court, has to go to the
All right, but it's not a point by... Sorry, I was thinking by damages you meant quantum.
And sixthly, in any case, the argument breaks down once it's recognised that on the Lord Chancellor's case, the High Court stage is optional, at least in a case where an appeal for damages. So in other words, a claimant can decide on the Lord Chancellor's case whether or not to bring one claim by an appeal, in which they also claim damages, or two claims, being the appeal to the further High Court. But if they bring just one claim by appeal, then that's a claim where the Lord Chancellor will be given notice and the court can join them. And so exactly the same problem would arise. Now, of course, the Lord Chancellor could get around that by saying, well, I won't participate in the contentious part of the claim about whether there's an error of law, I'll just come in on the damages if it comes to that. But if they can do that on an appeal, they can do it in the High Court as well. So none of the reasons will really run on the point about whether or not the Lord Chancellor has breached his independence by participating in proceedings. They've got another string to their bow, which is that they say, well, there's a second problem, which is it's not so much about being in court, it's about the judgments you make before you go to court. And then they say, well, it's what's objectionable is that we might decide to pay off a claim, or we might decide to settle a claim. If we do, then that amounts to us deciding behind the judge's back that the decision was unlawful. And that's a breach. It's not, we suggest, simply because forming a judgment like that and settling a claim is not at all the same thing as undermining the independence of the judge who made the decision. But even if there's any substance in that point, there are two, what we would suggest, straightforward answers to it. One is for the Lord Chancellor simply to adopt an approach that whereas they might compromise claims, they will never, they won't do it on the basis that they accept any wrongness or unlawfulness on part of the decision. The second option, which again arises in many contexts, is that the Lord Chancellor could take an approach where if they take the view that a decision is indefensible, they don't agree that it's unlawful, but they don't oppose it either. And that, again, will often happen in cases where the court is subject to some jurisdiction where it can't make a consent possession claim, for example. And it's then very common for one party who knows that they can't defend a claim not to agree to it, but say, well, I'm not putting up any opposition. So there are fairly straightforward ways around that problem if it isn't. So that's all I want to say about the Lord Chancellor's constitutional position. And I think that has probably taken me to most of the points. The rest of Ms. Appellant went through various points that have been picked up in her grounds of appeal on the second basis that there was no finding of abuse in this case. We of course accept it as a matter of judgment whether or not there is abuse, or whether there's any discretion to do. But overall, the complaints that are made are about matters that the judge expressly dealt with. It doesn't show that they were wrong around disagreeing or interfering. These, I think, are points that are all dealt with in our Scarlett argument. The point is me going through them again. There's only one point I made about discretion. If you were then it would be for you to exercise your discretion what to do. And you may take the view that given the argument that you've heard, this would be a case where there isn't actually any real risk of abuse here, because it's been pointed out, any decision will be made by a high court judge who would be the person who would hear that. That would be a level of seniority above the person who would hear an appeal in this case, and as appears to have been accepted today, that's something that would counter the collateral challenge argument. And that being so, even if you were to take the view that ordinarily there should first be an appeal, this is in a case where the case should be struck out on that basis, but you should give guidance in the future. This is just one other point about the availability of appeal, whether the claimant could reasonably appeal. And it's a point about the cumulative effect of appeals, in that although we accept that they can all be heard significant part of flagrant liability is the cumulative effect, and it may well be that that's something that can't be addressed satisfactorily, really addressed.
So sorry, your point is in principle there should be, or should have been, or should now be, several appeals?
Well, the Lord Chancellor,
There's only a single appeal against Judge Manner's order would on your submissions undermine everything else.
well, it might do. Although the way the point was argued below was that there would have that you might need to have several appeals against each of the orders. And
So, I mean, if that were the case, I'd see it might be the case. Certainly might be prudent to do it. You do it all in the same.
well, you could
You do it in a bundle. I don't quite know whether you'd actually have to issue five separate appeal notices.
Well, whether you have to or not, the substantive problem is that the court would then be seized of each appeal, but it's not clear that they would then be seized of the cumulative effect of those appeals, because
So this is your best point.
So that's why.
Yes.
It may be that appealing cases indeed doesn't do justice to their cumulative effect, whereas a High Court case can.
My Lord, you'll be glad to know that this is, I intend this to be a short reply with 5 points. The first point, my learned friend raised there would be an issue as to whether the Lord Chancellor is bound by the appellate determination if there were to be an appeal on the basis that there's a breach of Article 5. My Lord, we say the Lord Chancellor couldn't go behind that determination. That in itself would be a further lawful order of an independent judiciary that the Lord Chancellor can't then question in subsequent proceedings. Otherwise, the Lord Chancellor is again descending into the ring to question judicial orders in a case to which the Lord Chancellor was not a party. My Lord, my second point is about the set-aside, the point my Lord Justice Underhill made to me about the set-aside. What does set-aside mean? And then the no effect in CPR Part 21. I haven't had time to read the authority my learned friend handed up. What I would seek the court's permission is that we address that in the note that we're already going to be providing on the set-aside issue. These matters are all interlinked. What does set-aside mean? What does
Well, I suppose this new authority, not very, doesn't say very much.
I'd like to read it before I can
But
see
very well, I'm sure there can't be any objection to you dealing with that
I'm grateful.
in that way. I don't resile from my request, but the way Mr. Westgate put it perhaps makes my request less central, because really what he was saying was we're dealing with the abuse jurisdiction, which has a certain amount of elbow room in it. Whatever the formal effect of the words used in the order, it's quite clear that the substantive effect of it is that a judge has considered whether the claimant had capacity at any time in this litigation and found that he didn't, and that invalidated all the orders made, and that's good enough for his purposes. So if that's a good point, arguing about exactly what the effect of setting aside means, or what the effect the term has, becomes less central. But I'm not stopping you writing your note.
My Lord, I'm grateful. But my Lord, my third point follows on from that, in that if the case is now that the injunction is not effective in some way, shape or form, whether that's because it was set aside or because of the impact of CPR 21.34, then, my Lord, that underpins the entire basis, or undercuts the entire basis of the claimant's claim for damages against the Lord Chancellor. Because my lord, if we look at the particulars of claim in core bundle page 89, page 89, paragraph 43. The only basis upon which the claim is brought against the Lord Chancellor is if, contrary to, and this is paragraph 43 at the top of the page, contrary to the claimant's primary position against the first defendant, the injunction was not ineffective throughout by reason of CPR 21.34. Then the judicial acts amounted to a breach of the claimant's right to liberty. So, my lord, if that is now the claimant's position, then what is the basis of the claim for damages against the Lord Chancellor?
Well, the making of purported injunctions.
I'm sorry, my lord?
The making of purported injunctions, which actually led to him being arrested and detained.
Dingemans issued a piece of paper which had the consequence that the claimant was arrested and then remanded.
But, my lord, that's not the basis of the pleading.
As a matter of pleading,
my lord,
it may be that they will have to fiddle with the details of their pleading,
Yes.
but the substance is...
Yes. But, my lord, the other point I make on this is that my learned friend accepted that one could still appeal against that order, the order
Yes.
of Dingemans. And, my lord, that's supported by Mazhar, and the additional references in Mazhar, I promise to give your lordship a reference about how if something is unlawful, one can't say it never had it devoid of any legal effect. Those references are paragraph 27 of Mazhar, 31,
But once the order had been declared, the original order had been declared to have had no effect, an appeal would have been pointless. What would have been the point of appealing against an order which has been declared by District Judge, his name now, Swan, to be of no effect?
Well, my lord, because it said it still has legal effect, because that is what...
No, it didn't have legal effect. It had a real-world effect in the sense that it caused the arrest and detention of the claimant.
Yes.
The whole point is it didn't have that legal effect.
Yes. Well, my lord, that's the point, and that's what we say flows from Mazhar. It does still have legal effect, even if it's been set aside, and therefore it can still be appealed against. My lord, the fourth point is about what the blanket rule is, or what the blanket rule we say we seek is. And we say it flows from Mazhar that it is, the blanket rule is that if the order can be and ought to have been appealed, then it is an abuse. Now, where we spent last...
What, sorry?
If the order can be and ought to have been appealed, then it is an abuse to go by way of a Part 7 claim. Now, my lord, we say that is still a blanket rule. What we've spent a long time discussing today is whether this order in particular can be and ought to have been appealed. But if you're against me on my submissions on that, then the effect is simply that that is not an order that falls within the terms of the blanket rule that we are advancing. My lord, and the reason why we seek a blanket rule, why we invite this court to find that there is a blanket rule in this area, is because of the need of legal certainty and because of the need to assess how these provisions are supposed to work in practice. So, my lord, we say there is still a bright line rule. You might be against me on the facts of this case, that this order either could not be or ought not to have been appealed, but there is nevertheless still a blanket rule that applies in this type of abuse. So we're not in the realm of Mr. Justice Freedman's broad merit-based evaluation, broad merits-based judgment in every case when the Lord Chancellor is considering whether this is an appropriate procedure to adopt, or a claimant is considering, do I need to appeal, do I need to bring a Part 7 claim? So, my lord, what we say is that if there are situations, if there are orders that either can't be or ought not to have been appealed, then it would certainly be very helpful to have guidance about what those orders are. But that doesn't depart from our fundamental submission that there is still, in this context, for this type of abuse, based on the interpretation of Section 9, based on the constitutional principles, that there does need to be a blanket rule. That is the rule identified in Mazhar. If the order can be and ought to have been appealed, then it is an abuse to proceed by way of a Part 7 claim. My Lord, my final point is to deal with one of the last points made by my learned friend, where he said that there is no breach of the duty to promote the independence of the judiciary if what the Lord Chancellor is doing is making a submission to the judge in a Part 7 claim. But, my Lord, what that does is assumes that the Lord Chancellor has to defend all of these cases. So one has to make submissions to the judge in all of these cases. So it assumes that the Lord Chancellor cannot ever settle them, no matter how outrageous.
Well, but he did actually make submissions that are specifically about settlement, didn't he?
Well, my Lord, it wasn't about settlement. It was you either make submissions in every case or you stay silent. My Lord, but what
I think he said you could settle without admitting liability, or you could simply not oppose.
But, my Lord, if one settles without admitting liability, even though theoretically one is not admitting liability, one is paying money to a third party in respect of a judicial order.
Oh, very well, but that's a different point. I don't think you can say that he didn't deal with your point about inability to settle. He did. You are now saying, well, it's not a good answer.
Yes. Yes, my Lord, that's the point. This is not a good answer. It would mean that the Lord Chancellor would have to defend all of these cases, no matter how outrageous the behaviour of the judge, no matter how unalgorithmic.
No, you can settle.
But, my Lord, the point is, one can't settle in the Lord Chancellor's position.
Why not?
Because that is accepting that there is something wrong in respect
No,
to the decision.
you could be settled without admission of liability. People do that the whole time.
Well, my Lord, they do that the whole time. The point is that when one's in the Lord Chancellor's position, what that means when he settles it.
Yes, I see. You think the wrong message would be given.
Yes. My Lord, if the Lord Chancellor is going around paying out money in respect of judicial orders that he doesn't like, one can well see that that may be problematic for the promotion of judicial independence. My Lord, I'm just going to turn my back for a moment. My Lord, unless the court has any further questions, those are our submissions.
Well, thank you very much. We will be reserving our decision. Draft judgments will be circulated in the usual way so that the parties can agree the terms of any consequential order, or if they can't, provide short written submissions so that we can determine any disputed consequential matters at the same time as we hand down judgment. Also, of course, so that you can draw our attention to any typographical or other minor factual errors. The purposes for which the draft judgments are circulated are extremely limited, and that affects who they can properly be circulated to. And if you want any guidance on that, you can look at the Counsel General for Wales case, but I suspect it's pretty well ingrained by now. Thank you both and those behind you very much.
All right.